All right, good morning, everybody. Be seated, please. Good morning. Did y'all all have a good night? Anything eventful occur? Thank you. Ladies and gentlemen of the jury, today you get the case. And in fact, you'll get it in just a few hours. What remains are the closing arguments, the summation by counsel, and then the charge of the court, and then you'll be asked to retire to the jury room and to begin your deliberations. And so let's begin with the statements of counsel. The state, under our law, has the opportunity to go first and last. And Ms. Payne?
Your Honor, the state would waive opening and reserve concluding.
Thank you. Ms. Dunkar?
Thank you, Your Honor.
From the defense.
May it please the court?
Yes, ma'am. Thank you.
State. Good morning, ladies and gentlemen. At the beginning of this trial, I told you this was not a case of cold-blooded murder, that this was a case of a young kid snapping. For all intents and purposes, for without better language, Aaron freaked out. That's what you see on the evidence. What the state is trying to show you is cold-blooded murder is a traumatized, abused, neglected boy having realized that some tragic accident killed a girl he loved from a family he loved, and he lost it. The day of January 31st, 2011 was a tragedy for 2 children and 2 families. Amanda Calahan even said it best when she stated that January 31st, 2011, she lost a brother and a sister. The family, the Calahans, loved Aaron. Aaron loved the Calahans. You heard it from his own family. He spent more time at their house than his own family's house. He called them mother and father and brother and sister, and he came over there and helped them with their yard work. He did whatever he could to be over at that family because he loved them. You heard all 3 of the family members of Alana Calahan testify that Aaron would never have hurt Alana. He never showed any aggression towards any of them. He never, ever would have hurt them. It was a normal day by all accounts. Aaron went to school, Alana went to school, and Aaron got off the school bus. It was January, he was cold, he didn't have a hat, so he flips his hood up on his head and sticks his hands in his pocket. He's on restriction because he played ding-dong ditch with his cousin that weekend, being a stupid kid, and he knew he wasn't going to be able to go over to the Calahans for the next 2 weeks. So, because he loved this family, because he didn't want this family to feel like they were being rejected like he had been rejected his entire life, he felt it was very, very important to let them know he wasn't coming over, not because he didn't love them, but because he couldn't. So he walks to the bus stop, he tells Amanda, you know, I got in trouble, I can't come over anymore for the next 2 weeks, but I'll be back in 2 weeks. And he starts to walk home. As he's walking home down Miles Road towards his house, a bus driver passes him. He has his hood on, he has his hands in his pockets. They interpret that as him trying, plotting something. He was cold, it was January. And as he's walking towards his house, towards a house that's been filled with abuse and trauma his whole life, a place he doesn't want to stay, obviously, he starts to kind of procrastinate. He hangs out in the woods because, let's be honest, he'd rather be hanging out in the cold woods than at his home. If he can't go to the Calahans, cold woods is better than being in his house. So he's hanging out there and he thinks to himself, Amanda, being the de facto parent, sometimes forgets things. She's the de facto parent when the parents aren't in the picture. So maybe I should go up. I want to tell Alana that I can't be there because I don't want her to think that I'm not coming over because I don't love them. I don't want Amanda to forget to tell them that I'm not coming over because I don't love them. So he finally walks up there to tell Alana, excuse me. It's a normal day. He walks in the door, he unties his sneakers, he takes off his shoes. He knows Amanda's going to be back in the next 2 to 3 minutes. If he was planning something horrible, why would he have taken off his shoes when he knows the sister's coming right back? He goes in, he talks to Alana. It's tragic that he had stolen the father's gun before. It could have been as long as a week before, because no one saw that gun, and no one knew what happened to the gun after it was just sitting on the father's dresser with the ammunition stacked on top of it. What happened that day in that living room, we don't really know. We don't know. We don't know how far he was from the victim. You heard the medical examiner testify that there was no soot, there was no stippling, the typical signs of having close-range fire. So he doesn't know. He could have been all the way across the room from Alana. We don't know. He could have been, for all we know, in another room. It's unlikely, but we don't know where he was. We don't know how close he was. We don't know if he was sitting on the table, messing with the gun like he said, trying to get it to unload. Was it stupid to do that in the house? Yes. He's a 14-year-old kid. He does not have the common sense that a lot of us adults would have. He is a child. And we don't know what happened. What we do know is when that gun went off, when Alana fell over, Aaron freaked out. He's a 14-year-old kid. I challenge any of you to think about what would happen if a tragic accident happened and you shot someone you loved by accident. I don't think any of us
Objection,
would.
Your Honor.
Sustained. Ms. Donner, you want to approach, please?
Aaron did the only thing he could do to think of to save the Calahan's love. That was his panic. He realized he killed the daughter of a family that he loved. He realized he killed a girl that he considered his sister, that he loved, that he never would have hurt. And all he could do was think to blame someone else. It wasn't a good lie. The evidence was going to show that it didn't happen that way. But he was a 14-year-old kid. You heard his bus driver say that day he was normal. He wasn't brooding. You heard his cousin say that whole weekend, that whole day, he was normal. He wasn't brooding. He wasn't plotting anything. He was just being normal Aaron. And as the police interrogated Aaron for hours and hours and hours and left him sitting in there, he tries to make his story fit the facts. He doesn't know what else to do. He realizes his bad lie about some other guy did it isn't gonna fly. And he says on that tape, I didn't want the Calahans to be mad at me. That's what his fear is. That 14-year-old fear. Not the fear that he has killed a girl, but that he's scared that this family is mad at him. That's a 14-year-old right there. That is a 14-year-old who had an accident, who had a tragic accident, is trying to figure out some way to save the one family that has truly accepted him and truly loved him during his life. He doesn't know what to do. He is out of his mind with panic. In fact, the investigator says it best when he says that he sees a person who is so scared to dang death that he's just trying to figure out a way to make it right. And that's what Aaron was doing. Aaron was trying to figure out a way. He's been rejected by his mother. He's been rejected by an adoption family. And he has had trauma from every single adult in his life from the time he was an infant. And all he can think about is, oh my gosh, it's about to happen again. I made a stupid mistake, and this family that finally accepted me, finally loved me, that I loved more than anything, is gonna be mad at me, and I'm not gonna have them either, and I'm gonna be back to being by myself. You heard his sister testify that most of the abuse went unreported. He doesn't trust adults. How can he trust adults when these things were happening and no one did anything about it? They let it happen. Instead of calling DFACS when he was left in the car as a child and a son, they said, oh, just go get him out. They didn't call DFACS. When his older brother was born from an incestuous relationship, did they call DFACS and remove her? No. They let it happen again and again until Aaron was born. Until Aaron was left with his mother, who at that time was young, had 3 young children, and then finally was removed from that house when he was 5, after 5 years of who knows what. Aaron is a kid. If we're perfect, Aaron is a kid, and his statement shows just that. You see a kid trying to weasel his way out of what happened because he can't comprehend that an adult might actually, number 1, believe that it was an accident, and number 2, might not reject, punish him for that. So he's trying to figure out some way, oh my gosh, I know they're not on my side, Adults are never on my side. What am I going to do? That's what's going on. All of that evidence that the state is going to point to show that he was a cold-blooded killer is him being a kid, him being a traumatized, scared, abused kid. The calm reaction after this happened, he was traumatized. If we're perfectly honest, sure, he didn't react like a normal person would react. Aaron's not normal. Aaron is a 14-year-old child who has experienced 14 years of abuse and neglect.
Objection, Your Honor, that fact is not in evidence.
Ladies and gentlemen of the jury, let me just make sure that we make this abundantly clear that during the closing arguments, during the summation, and also at any point during this trial, nothing that the lawyers say, except for what's come in by way of when they say stipulations, those come in, but everything else that the lawyers say is not evidence. It may, and in summation, this is what they are summarizing for you what they think the evidence has shown. You will recall the evidence, and the only evidence that you can apply in this case is the evidence that came in from the witness stand or that came in through those exhibits that were admitted into evidence. If you hear anything else that's other than that, you can just say you can disregard it because it's not evidence. Ladies and gentlemen of the jury, it's up to you to recall what the evidence in this case has been. And so with that admonition, I'll allow counsel to continue, but y'all will recall what's evidence and y'all will sort out if anything has been said that was not evidence that's properly brought before you during the trial. Y'all sort that out. Ms. Duncar, you might continue.
Thank you, Your Honor. I'll clarify. He was removed from his mother's house when he was 5 years old after there were allegations of abuse. As soon as a week before this incident, he came home from school beaten up. Did his guardian call any authorities? No. I would consider that neglect. He was robbed the weekend before by some boys. Did anyone call the authorities? No. So Aaron is not going to have the normal reactions. You can't look at his emotional reactions and see a normal kid's reactions. Just because he's calm, just because his emotions aren't what one would expect, does not mean he planned a cold-blooded murder. It means he's an abused child who's stuck in a traumatic incident, an accident, a tragic accident that he is completely freaking out over, for lack of a better term. That's what happens. That's what you see. You see a panicked child. The judge is going to explain to you later that before you can return a verdict of guilty, you have to find that beyond a reasonable doubt, Aaron committed this murder. He's also going to tell you that a reasonable doubt is that of a fair-minded juror reasonably seeking the truth. Much like most of my time in law school, legal jargon does not make sense to the normal person or the normal law student. And so I find it sometimes helpful to put it in things that I can understand. I've recently taken up rock climbing, and I like to free climb without ropes. Reasonable doubt, whenever I go rock climbing, before I'm going to let go of this hand when I'm reaching for another rock, I have to know beyond a reasonable doubt that that rock is going to hold, because my life is depending on that rock. Just like Aaron's freedom is depending on you all determining that beyond a reasonable doubt, he committed these offenses. If there's any little wavering up here, they haven't proven it beyond a reasonable doubt. And I would suggest to you, ladies and gentlemen, that the state's rock is mighty shaky. There are many, many things that they have not been able to explain that it's just as likely that it was an accident as it was anything else, and perhaps more likely that it was an accident. Why did he take his shoes off? He had a reasonable reason for having this gun that was not having anything to do with Alana. You heard his cousin testify that he and his cousin had been robbed by some boys that weekend. You also heard his aunt testify, or his sister, testify that he came home from school the week and a half before, beaten up. He had bruises on his face, and no one did anything about it. What is he supposed to do? He then decides that it's his job to protect himself because adults haven't protected him all along. It was probably not a good decision. He shouldn't have taken Mr. Calahan's gun, and we don't dispute that. We don't dispute the charge of theft by taking. He took that gun. That happened. The state has not been able to prove to you where this gunshot happened, how close Aaron was, how far away Aaron was, where Aaron was standing in the room. Aaron knew Amanda's schedule. Aaron knew Amanda was going to be returning home in a minute or two. It would make absolutely no sense for him to go and plan a cold-blooded murder, to have 2 minutes to get in, hide the body, get out. Even a 14-year-old knows that. Even a 14-year-old would not be that stupid to do that. You also heard all 3 members of the Calahan family and all of Aaron's family testify that Aaron loved that family. He loved them more than his own family. He finally had a family that accepted him, that took him on vacations, that fed him dinner, that bought him presents, and that he never would have hurt. All he wanted to do was help his family. You heard Paul Calahan testify and Betty Jo Calahan testify that Aaron would come over and he would work for them. He wasn't just coming over there eating their food. He would come over and he would help them work on their house. He would help them mow their lawn. He would help them take care of their house. He did whatever he could to stay in their good graces. He would never have hurt that family. And like I explained, his behavior after the fact explains nothing. It explains nothing other than he is a kid, and a kid who has unusual reactions to emotions. We heard that from his sister, that when he was a little kid, when he was first removed from his mother's house, he used to crawl under a chair and rock back and forth when he would get in trouble. Or he would curl up in the fetal position in a corner. Those aren't normal reactions for children. And certainly, he's not having normal reactions now. That does not make him a cold-blooded killer. We heard testimony from his own bus driver, from Amanda, and from Tommy that on that day he was normal. There was nothing remarkable about Aaron. He wasn't sitting there plotting. He wasn't sitting there brooding. He was normal. He was Aaron. You heard all of the Calahans testify that Aaron had never exhibited any aggressive tendencies. He had never been aggressive or violent with the kids. He had been nothing but good with all of the Calahan children, all 4 of the Calahan children. Also, the state is going to try and say that Aaron hanging out in the woods was him lying in wait, him waiting to walk up to the house when Amanda wouldn't be there. But I would suggest to you, a kid that spends all of his time at the neighbor's house not wanting to be home, perhaps he just doesn't want to be home. Perhaps he doesn't like being home. And if his choice is between hanging out in the cold woods and the home, and he chooses the woods, there are some kids that would do that. And there are some kids who don't trust adults, who don't trust their family, that would do that. And that was what he was doing. Additionally, this supposed provocation that led to him planning this murder, this yelling of Miss Calahan at Aaron the week before. You heard 3 differing accounts of that. You heard Miss Calahan say that she yelled at him and she was very angry and she had never screamed at him before and all of this. And then you heard Amanda state, she was angry, but she didn't yell at him. She raised her voice a little bit. And by all accounts, Aaron took that. He was respectful, he didn't have an attitude, and he went home. He listened to them. There was no anger about that. And you also heard that the rules weren't quite straight between the Calahans. You heard Miss Calahan testify that after that he was not allowed over. But you heard Mr. Calahan and Amanda Calahan testify that no, the rule changed to he couldn't be over when there was no adult there. We don't really know what happened that day. What we do know is she raised her voice a little bit. Aaron took it. Aaron didn't have an attitude. He didn't huff off. He took it and went home. But again, the largest issue the state is going to hammer is his demeanor. That he acts like a cold-blooded killer. That he's lying to cover his tracks. Yeah, he's lying to cover his tracks because he had no idea that an accident, that telling from the time it happened, that an accident would set him free. He had no idea. He was a kid. And Kids will lie, and they will lie, and they will lie, and they will lie. And they'll lie when you provide the evidence to them, and they'll try and make it fit, just like Aaron did, acting like a kid. Does it mean he was a cold-blooded killer? No. It means he's a kid. It means he's a kid who got involved in a tragic accident and is trying to figure out, for the life of him, how he is going to save his relationship with the Calahans and how he's not going to lose this one family that had finally loved him. We concede that Aaron should not have taken Mr. Callahan's gun. He should not have had control of that gun. But this is not a cold-blooded murder. This is an accident. This is an accident that shouldn't have ever happened. And when that accident happened, Aaron lost his mind. That's why he acted that way. Not because he was happy that this happened, not because he had been planning that this happened, but because he had no way to process what had just happened. He had just accidentally shot a girl he loved from a family he loved who he didn't want to lose, and he had no idea how to deal with that. There has been no premeditation shown. There has been no malice shown. All the testimony has shown is that Aaron loved this family and that Aaron never would have intentionally hurt this family. And ladies and gentlemen, because of that, I will ask you after deliberations to come back with a not guilty verdict for Aaron Schmidt based on accident.
Appreciate your attention throughout this trial. I know it isn't always easy, and I don't know that it ever does. Begin to be easy to hear things like what happened on January 31st of 2011. It's also easy to forget the real reason that we are here, and that is because of this sweet face. She was 14 years old. She got off the school bus that day. She came home with her sister. She got on Facebook, probably like most American teenagers do every day. And like most American teenagers do when they are on Facebook every day, she's glued to the computer. She has no clue the danger that is ensuing. She has no clue of the man who is hiding in the woods, waiting for his opportunity to strike. When you deliberate, you should consider the timeline of events in this case. Paul Calahan was out of town. He had left 8 days prior. A few days later, Aaron Schmidt is in the Calahan home without permission. Alana comes home and she hears a noise, and it scares her to death. And it's Aaron Schmidt. He does not have permission. He knows he's not supposed to be there. And Betty Jo Calahan freaks out. What are you doing here? Why are you in my house? You need to go. She's mad. She's angry. She told you she was mad. Aaron coyly grabs his things and leaves without really saying much of anything. But his blood is boiling. Not at Betty Jo, but at Alana. She is now interfering with this relationship that he has with the Calahan family. She is causing Aaron to start panicking that maybe he is going to lose this family that he loves. The main focus in this family was the boys and Paul, the brothers and the father that he never had. As time progresses, we go to Betty Jo's statement where she says that there are only 2 days a week that she's not there when Alana gets off the bus. And when she's not there, Amanda's there to pick her up. The defendant, as Ms. Chitty told you, he gets home at 2:05 every day. That was what she said on her statement to investigators the day that she was interviewed. So for an hour and a half in the freezing rain, Aaron Schmidt is walking around with this gun in his pocket. As you might recall, this gun, when it was found with the hammer down. Single action mode. Dennis Miller told you that there's only one way that this firearm gets in single action mode with a chambered round. And that is if this firearm had been fired in single action mode. When you talk about this firearm being fired in single action mode, not very much. Not very much. 4.5 pounds of pressure. It's not an accident. It doesn't accidentally go off, but it sure does make things a heck of a lot easier than pulling it when it's not in single action mode. You have this firearm in your deliberations room, pull the trigger. He walked in that house with a hammer down, on a firearm that he had stolen from the Calahan home. When we talk about this timeline, Amanda is at the end of the driveway, right here. She sees the defendant come from his home, or come from the direction of his home, specifically for the only reason of talking to Amanda, because he then turns around and goes back that way. Probably 2 or 3 minutes later, after Alana gets off the bus, which she gets off the bus at 3:32 and 45 seconds, according to the GPS monitor. Cheryl Lowe sees him right here, acting very strange. Hands in his pocket, hands on the firearm, hood over his head. She goes down here, she makes a circle at the end of this road, comes back, and by the time she's at this stop sign, she sees the defendant not over here at his house, but over here at the wood line. Probably 5 or 6 minutes after Alana was dropped off, so this takes us about 3:38, 3:39 p.m. And he makes this 5-minute trek to the back of the woods, and he waits. He waits for Amanda Calahan to leave. Chase gets off the bus at 3:52 p.m., and we know that because of the GPS monitor. And when Amanda got to the end of the driveway that day, Chase was already off the bus. Amanda told you that it takes about 1.5 minutes, 2 minutes before to get to the end of the driveway and back. So she probably left about 3:50. She gets to Chase probably 3:53 and is home by 3:55. In that short 4 to 5 minute window, the defendant walks in this house, takes off his shoes like he does every single day, because he doesn't know what Alana's doing in there. He has to be normal. He walks in with a firearm, loaded, chambered, ready to go. In the easiest mode that he can have it in to fire that gun. He walks up to Alana Calahan and he shoots her right in the back of the head. We know where he was. We know where she was. You have the trajectory from the bullets on that computer screen. She is staring at that computer screen like so many teenagers do every single day, glued to Facebook, uploading her photographs, not even aware of the danger. All of this happens. He takes off his shoes. He walks in. He shoots Alana. She falls over. He panics by his own account. Then he drags her body all the way down the steps, all the way around that pile, all the way around the wood line and back onto that trail. 200 feet. 120-pound body, 200 feet. Then, by his own account, at this point, he's right about here. He runs all the way over here, hides the gun deep in the woods, and not just throws it, he hides it, covers it back up. Here's the truck, runs around the front of the house, runs in the house, tells Amanda this crazy story about this person that he doesn't even really know what looks like. They've been run out of the house. He puts his shoes back on, runs back out around the corner of the house. Again, at this point, he's over here. Pretends to get sick, runs to the body, and then 911 call at 4:02 p.m. Was there even enough time to have a conversation? No, there wasn't. There was not enough time to have a conversation. This gun, out of the hour and a half he's home from school, out of the time he's hanging out in the woods waiting for Amanda to leave, that's not a coincidence. It's not a coincidence that he took his shoes off at that house. Because if he was really only going to that house to tell Alana that he was grounded for 2 weeks, why did he take his shoes off? Why did he wait for the 3 minutes of the entire day that he is alone with Alana and Amanda, he knows, is safely down at the end of the driveway picking up Chase? Why does he wait till that minute to check and try to get the bullet out of the gun? A gun that he's had for days. A gun that he not only has the box to, he has the manual to it. But he waits for the 3 minutes that he's alone with Alana to figure this out. Does he even have enough time to really actually sit there and do whatever he's doing with the gun like he proclaims he was doing? No. Because this was cold-blooded, premeditated murder. That's why. The defendant knew he was not supposed to be at the Calahan's home when the Calahans are not there. And while defense counsel pointed out that maybe the Calahans were confused about this issue, the defendant was not confused. And how do you know that? Because Tommy told you. What conversation did they have? Aaron was very particular about what he told Tommy. He was not allowed to touch the guns. He was not allowed to be there unless the parents were home. And specifically, he was not allowed in the bedrooms. Where did those rules come from? Why would the Calahans make those rules so clear to Aaron that he relays them to his best friend? He's obsessed with the Calahan family. On his statement to investigators when they're asking him about his Facebook account, what's his Facebook name? His Facebook name is Aaron Calahan, not Aaron Schmidt. Miss Chitty told you that he called Betty, Joe, and Paul Mom and Dad. Yet this family that he loves, Alana, that he supposedly loves, he doesn't try to help her. She is gurgling her own blood. She is gasping for air, her last breaths of life, and he does not care. He doesn't care. He doesn't try to help her. He's more concerned with getting rid of the body. This is not an accident. This is not an accident. And when you consider whether or not this is an accident, you consider his statement. We would have never gotten to the point that it was an accident, but because this is hours after this murder has occurred. When they start confronting him with the evidence, at this point, they're learning for the first time themselves, the investigators. He can't deny that. Because in his mind, he's thinking, well, that adds up to the truth. This ain't looking too good for me. So he starts changing his facts. He starts changing everything. He starts getting closer, but he doesn't want to quite get there. until they say Alana's fingerprints are on the gun. What about this gunpowder? He starts thinking, not getting away with it anymore. I'm gonna have to come up with something better. So first, after he puts the gun in his hand, first it's that he was on the table. This kid is 6 feet tall. He's on a table trying to do this gun. Well, that doesn't make sense. Then he's trying to unload the hammer because Alana wants him to show her how to use the gun. That doesn't make sense either. By all accounts, Alana shot in the back of the head. She never even saw it coming. Then he's by the glass door, which is on the right side of Alana. We know she shot on the left side of her head. And the trajectory from the bullet strike on the table is not consistent with that either. He's in front of her. He's behind her. He's everywhere but on the left side of the body, which is where she was shot. She wasn't turned around this way. She was sitting at that table with a computer screen straight in front of her face. Whoever shot her from the left side. He admits the gun was in his hand, but he's not going to tell the truth. He's not going to give the investigators the truth. He's only going to give them what he has to give them to comport with what the evidence that they're confronting him with says. Then we have his family that talks about he's not like this, he wouldn't do this. Gosh, they sure have a strange way of showing it. Diana Chitty acted like she couldn't believe brother would never do this. He would never do this. But she wanted to get him checked. Heard that on her statement. She had a bad feeling about those woods. He just needed to stay close to home. She didn't sound very certain about him not being involved. Not on her statement. She was so persistent about checking with her brother to figure out what time Aaron left that day. Asking him, well, what TV show was on? How long have you been home? Why is she that concerned? She lied about not receiving a phone call and admitting the fact that he was being investigated. That's what she thought at the time. She didn't want to tell you that in court. That's what she thought on that tape. And then at the end of her statement, she says, he don't hurt kids and animals and stuff like that. What an odd thing to say. Then we have Tommy. This is a best friend of the defendant. He's a good guy, that's what he says. But then, at the end of his statement, everybody knew he was going to do something like this one day. Is that a good guy? No. The judge is going to charge you on malice murder. Malice murder defined is where a person unlawfully with malice aforethought causes the death of another. Malice can either be express, which means deliberate, or implied, where there's no provocation, just a depraved and malignant heart. It does not have to be ill will or hatred, but malice is the unlawful intention to kill without justification, excuse, or mitigation. Exactly what we have here. The judge is also going to charge you that when all of the circumstances of the killing show a depraved and malignant heart, that is malice. The defendant has a depraved and malignant heart. How do we know that? He drug her body through the woods, makes up this whole charade about this whitish, blackish man wearing whitish, blackish, or grayish pants. That goes on for hours. When he's sitting there on the phone with the 911 operator, while Amanda who is so hysterical because her sister is on the ground with blood coming from her mouth. Amanda is trying to save this girl, save her baby sister. And she's so hysterical that he takes the phone from her. He gets on the phone. She hands him the phone. He doesn't care about helping her do CPR. He's telling the 911 dispatcher this crazy story. That's a depraved and malignant heart. A depraved and malignant heart watched Alana slump over and fall to the ground. Watched her blood gush from her head. And so callously talked about hearing her moan and taking her last breaths of life. That callous heart did not fake one tear until 1 hour into his interview. 1 hour. This girl he supposedly loves, he's talking about her like she's an object. Yeah, I drug her by the arms. She was face up. Her head was just going back and forth, back and forth. That's sick. He doesn't love that girl. It's a depraved and malignant heart to the T. You have to ask yourself, is that really what a reasonable person would do? We don't ask you to check your common sense at the door here. You have to find that he is guilty beyond a reasonable doubt. Not every doubt, but a reasonable doubt. It is not reasonable to have to explain his bizarre conduct with things that are not in evidence. It could have happened. This accident could have happened. No, it didn't. Be reasonable about this. You have this short window of time. You have this firearm in single action mode, ready to fire, and it's loaded. It's chambered. Is it reasonable for him to have had this gun for several days? But the 1 second that he happens to be in close proximity with Alana Calahan, that it just so happens to go off? And once he tells investigator it was an accident, why not just be honest about it? He never is honest about it. He never tells them. He never admits. The way that the indictment reads is that that he would have committed aggravated assault, and obviously that Alana died as a result of that. As a matter of law, assault is simply where you assault another person with a deadly weapon. The judge is also going to charge you that as a matter of law, a firearm is a deadly weapon. And this gun is pointed at Alana's head. Done. You have to be real about this whole thing. This whole conjured charade. He never explained how that gun box got at his house. He never explained how that ammo was there, or why that manual was there, why it was all right there next to those gloves underneath the bathroom in a hidden little spot. The manual was in his bedroom dresser drawer. Clearly he's in there reading it. He separates that from the box. He never explains why on God's green earth he decides to take that loaded firearm back over to the Calahan's home that day. The investigators asked him 4 times prior to him admitting that this was an accident. Was this an accident? No. Was this an accident? No. Was this an accident? No. Finally, when the evidence is too much for him to overcome, you know what? It's an accident, which is eerily similar to this trial. Beginning of this trial, you heard he snapped. He snapped. Poor, pitiful Aaron Schmidt. This wasn't an accident. What changed? He wasn't at school, or he was at school and he got beat up. So he had to steal this gun. and he went over there and he snapped. That's what we heard at the beginning. There's no evidence of that. So you know what? Now, guess what? It's an accident. They asked him, was it an accident? Was it an accident? Was it an accident? No. But now, at the end of this trial, it's an accident. That defense is a shifting, inconsistent defense. That's only indicative of one thing. That's guilt. I told you at the beginning of this trial, the truth never changes. Aaron Schmidt tried to make this whole thing work for him. But in his case, the truth was worse than a lie. Because the truth was that he murdered that girl. Poor, pitiful Alana Calahan. Poor, pitiful Betty Jo and Paul Calahan for taking this guy into their home, feeding him at their table, treating him like a son. Birthdays, Christmases, they wanted him in their life. They had no idea that he would take their precious little daughter from them. She will never go to high school. She will never graduate from high school. She will never go to college, and her father will never walk her down the aisle. Why? Because Aaron Schmidt is selfish. He wanted what she had, and she threatened that. So in his sick and twisted mind, get rid of the problem. Get rid of Alana. And that's exactly what he did. When he waited in those woods, when he went over there with that loaded firearm, and when he pulled the trigger, and when he drug her body to hide it, and he hid the firearm, did you hear him in a statement? I forgot my shoes. Crap. That's why he went back. He was just going to run home. Feeling like he wasn't even there. That is sick. That is a depraved and malignant heart. This man is guilty of every single charge. He's guilty of malice murder. He is guilty of felony murder. He is guilty of stealing that firearm. He is guilty of possession of a firearm during the commission of a crime. The state has carried its burden. I ask you to find a jury reflecting that, to find a verdict reflecting that. Thank you.
Thank you, ma'am. Nathan, can you clear that for me? All right, ladies and gentlemen of the jury, that brings us to the charge. And again, I have to present the charge to you by reading it. You can take notes if you like, but you will actually have the copy of the charge that I'm reading from. You'll have this with you when you begin your deliberations, which will be in just for a short while, probably with less than half an hour. Ladies and gentlemen, you are considering the case of the state of Georgia versus Lacy Aaron Schmidt, indictment number 2011 CR 436. The grand jury of Columbia County has indicted the defendant with the offenses of count 1, murder, count 2, felony murder, count 3, possession of a firearm during the commission of a crime, and count 4, theft by taking. And ladies and gentlemen, I'll read to you one more time the indictment, and you will also have the indictment out with you during your deliberations. The grand jury selected, chosen, and sworn for the County of Columbia in the name and behalf of the citizens of Georgia, charged and accused Lacy Aaron Schmidt with the offense of murder, for that the said accused, the County of Columbia and the state of Georgia, on the 31st day of January 2011, did unlawfully and with malice aforethought caused the death of Alana Mae Calahan, a human being, by shooting Alana Mae Calahan with a handgun, contrary to the laws of this state. An account to the grand jurors chosen and sworn for the County of Columbia and in the name and on behalf of the citizens of Georgia, further charge and accuse Lacy Aaron Schmidt with the offense of murder, for that the said accused in the County of Columbia and the state of Georgia on the 31st day of January 2011 did, while in the commission of the felony of aggravated assault, caused the death of Alana Calahan, a human being, by shooting Alana Calahan with a handgun, a deadly weapon, according to the laws of this state. In count 3, the grand jurors further charge and accuse Lacy Aaron Schmidt with the offense of possession of a firearm during the commission of a crime, for that the said accused in the County of Columbia and the state of Georgia on the 31st day of January 2011 did have on his person a firearm, to wit, a Taurus handgun, during the commission of a crime, to wit, murder. Said crime involving the person of Alana Calahan, and which crime was a felony, contrary to the laws of this state. And in count 4, the grand jurors further charge and accuse Lacy Aaron Schmidt with the offense of theft by taking, for that the said accused in the County of Columbia and the state of Georgia on the 31st day of January 2011 did unlawfully take a firearm, to it, a Taurus handgun, the property of Paul Calahan, with the intent to deprive the owner of said property contrary to the laws of this state. Well, ladies and gentlemen, this defendant has entered a plea of not guilty to this indictment, and the indictment and the plea form the issue that you are to decide. Ladies and gentlemen, I remind you that neither the indictment nor the plea of not guilty should be considered by you as evidence. Ladies and gentlemen, I charge you on presumptions of innocence and the burden of proof and reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. Now, no person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or to disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or an arbitrary doubt, but it is a doubt for which a reason can be given arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. Now, if the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Ladies and gentlemen, I charge you that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize the conviction of the defendant. Ladies and gentlemen of the jury, it is my duty and responsibility to determine the law that applies in this case and to instruct you on that law, and you are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence that's been presented, and then you must apply the law that I give to you in this charge to the facts as you find them to be. Ladies and gentlemen, evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and the exhibits admitted during the trial. It also includes any stipulations, and those are facts that were agreed to by the lawyers. It does not include the indictment, the plea of not guilty, the opening statements or the closing arguments by the lawyers, or the questions that were asked by the lawyers. Ladies and gentlemen, I charge you on direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. Direct evidence is evidence that points immediately to the question at issue. Now, evidence that may be used to prove a fact by inference is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by the use of direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. Now, to warrant a conviction on circumstantial evidence, the proven facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of the accused. Now, the comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Ladies and gentlemen, you must also determine the credibility or the believability of the witnesses. It is for you to determine which witness or witnesses you will believe, or which witness or witnesses you will not believe if there are some whom you do not believe. In deciding credibility, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or the improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility insofar as it may have been shown in your presence and by the evidence. Now, ladies and gentlemen, as to expert witnesses, testimony has been given by certain witnesses who in law are termed experts. The law permits persons who are expert in certain areas to give their opinions derived from their knowledge of that area. The weight that is given to the testimony of expert witnesses is a question to be determined by the jury. The testimony of an expert, like that of any other witness, is to be received by you and given only so much weight as you think it is properly entitled to receive. You are not required to accept the opinion testimony of witnesses, expert or otherwise. Ladies and gentlemen, to impeach a witness is to prove that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, or by proof of contradictory statements previously made by the witness about matters relevant to the witness's testimony and to this case. If any attempt has been made in this case to impeach a witness by proof of contradictory statements previously made, you must determine from the evidence, first, whether any such statement was made, second, whether such statements were contradictory to any statement the witness made on the witness stand, and third, whether such statements were relevant to the witness's testimony and to this case. Now, if you find that a witness has been successfully impeached by proof of previous contradictory statements, you may disregard that testimony unless it is supported by other credible testimony. The credit to be given to the balance of the testimony of that witness would be for you to determine. Now, it is for you to determine whether or not a witness has been impeached and to determine the credibility of such witness and the weight the witness's testimony shall receive in the consideration of the case. Ladies and gentlemen, in this case, a statement that the defendant has allegedly made has been offered for your consideration. Y'all may be very thirsty too. If you may, is uncomfortably thirsty, let me know. As I stated before, a statement that the defendant has allegedly made has been offered for your consideration. Now, before you may consider this as evidence for any purpose, you must answer the following. First, was the defendant warned of his constitutional rights, and did the defendant understand and knowingly give up such rights? Now, those constitutional rights that must be explained and that must be understood and given up by the defendant before any statement is given by the police are as follows. 1, the defendant had a right to remain silent. 2, if the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. 3, the defendant had a right to consult with a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. Now, in this case, the defendant is a juvenile. In considering whether a statement made by a juvenile defendant was made with a knowing and intelligent waiver of his constitutional rights, you are to consider the totality of the circumstances. Factors that you may consider to determine whether the defendant has made a knowing and intelligent waiver include, but they are not limited to, the following: the age of the defendant, the education of the defendant, the knowledge of the defendant as to the substance of the charge and the nature of his right to consult with an attorney, whether the defendant was allowed to consult with relatives or an attorney, whether the defendant was interrogated before or after formal charges had been filed, the methods used in questioning, the length of the questioning, whether the defendant refused to give statements on prior occasions, and also whether the defendant withdrew or denied making the statement at a later date. Now, the burden of proof is upon the state to establish that the warnings of all rights mentioned were given, and that they were understood, and that they were knowingly given up by the defendant. The other issue that you must address is whether the defendant's statement was voluntary. And by voluntary, we mean that it is freely and willingly given. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, or use of violence, fear of injury, or suggestions or promises of any leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. Now, you may consider the legality, the duration, the conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. The burden of proof is upon the state to establish that the statement was voluntary and that it was freely and willingly made. Now, ladies and gentlemen, if you find that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, that the statement was voluntary, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to any or to all of such evidence. If you fail to find any one of the conditions that I have just described, you must disregard the statement entirely and give it no consideration in reaching your verdict, except for the purposes of impeachment. Now, the defendant in this case is under no duty to present any evidence tending to prove his innocence and is not required to take the stand and testify in the case. If the defendant elects not to testify, no inference that is hurtful, harmful, or adverse to the defendant shall be drawn by the jury, nor shall such fact be held against the defendant in any way. This defendant is charged with a crime against the laws of this state. A crime in this state is defined as a violation of a statute of this state in which there's a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Now, whether or not you draw such an inference is a matter solely within your discretion. Ladies and gentlemen, criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by the statute. Now, ladies and gentlemen, this defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural consequences of those acts. Now, whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Ladies and gentlemen, now to more substantive charges. I've charged you first on a preliminary charge of venue. The law provides that criminal action shall be tried in the county in which the crime was committed. Venue, that is, that this crime was committed in Columbia County, is a jurisdictional fact that must be proven by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Now, venue must be proven by direct or by circumstantial evidence or by both. Now to the more substantive charges. I charge you on malice murder. Ladies and gentlemen of the jury, a person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. Express malice is that deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may, but need not, be implied when no considerable provocation appears and when all of the circumstances of the killing show an abandoned and a malignant heart. It is for the jury to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but it is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. Yet if malice is in the mind of the accused at the time of the doing of the act or killing and moves the accused to do it, then such is sufficient to constitute the homicide as murder. As to motive, proof of any particular motive is not essential to constitute the crime of murder. Evidence of motive, if any, is submitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. Ladies and gentlemen, I charge you on felony murder. A person also commits the crime of murder when, in the commission of a felony, that person causes the death of another human being with or without malice. I further charge you that under the laws of Georgia, aggravated assault is a felony offense and is defined as follows. A person commits the offense of aggravated assault when that person assaults another person with a deadly weapon. Now, to constitute such an assault, actual injury to the victim need not be shown. It is only necessary that the evidence show beyond a reasonable doubt that the defendant attempted to cause a violent injury to the alleged victim. The state must also prove as a material element of aggravated assault, as alleged in this case, that the assault was made with a deadly weapon. Ladies and gentlemen, I charge you that a firearm, when used as such, is a deadly weapon as a matter of law. Now, I charge you that the offense of felony murder does not require malice or the intent to kill. It does, however, require that the defendant possess the requisite criminal intent to commit the underlying felony. Now, a person commits simple assault when that person attempts to commit a violent injury to a person of another, or commits an act that places another in reasonable apprehension of immediately receiving violent injury. Ladies and gentlemen, I'm going to read this to you again and instruct you that we're going to follow the first part of this. A person commits simple assault when that person attempts to commit a violent injury to the person of another. I charge you now on possession of a firearm during the commission of a crime. A person commits the offense of possession of a firearm during the commission of a crime when the person has on or within arm's reach of his person a firearm during the commission of or any attempt to commit any crime against or involving the person of another, in which crime is a felony. I further charge you that the offenses of murder and aggravated assault are felonies under the laws of this state. Ladies and gentlemen, I charge you on the offense of theft by taking. A person commits the offense of theft by taking when that person unlawfully takes any property of another with the intention of depriving the other person of the property, regardless of the manner in which the property is taken or appropriated. Ladies and gentlemen, I charge you on the defense of accident. No person shall be found guilty of any crime committed by misfortune or accident in which there is no criminal scheme, undertaking, or intention. An accident is an event that takes place without one's foresight or expectation, which takes place or begins to exist without design. If you find from the evidence that the incident that is the subject matter of this case occurred as a result of misfortune or accident, and not as a result of a criminal undertaking or criminal negligence, then it would be your duty to acquit the defendant. When the issue of accident is raised, the burden of proof is on the state to negate or to disprove it beyond a reasonable doubt. Any evidence as to misfortune or accident should be considered by you in connection with all of the other evidence in this case. If in doing so you should entertain a reasonable doubt as to the guilt of the accused, it would be your duty to acquit. On the other hand, should you believe from the evidence as a whole that the defendant is guilty beyond a reasonable doubt, you may convict. Now, ladies and gentlemen, in just a few minutes, you'll be in the jury room to begin your deliberations. And I charge you that this defendant is charged in this indictment with 4 separate counts. It is necessary for you to consider each count separately. As to each of the counts in the indictment, if after considering the testimony and the evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Columbia County, Georgia, did, on or about the 31st day of January 2011, commit the offense as alleged in that count of the indictment, you would be authorized to find the defendant guilty of such count. In that event, as to such count, you may specify your verdict by having your foreperson place a mark next to the language guilty of the offense alleged in that particular count of the indictment. And to assist you, we have prepared a verdict form for your use during your deliberations. Your foreperson would merely indicate by checking guilty of the offense of malice murder, or, as I'm going to cover now, on the other hand, if you do not believe beyond a reasonable doubt that the defendant is guilty of the offense charged in such count, or if you have reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant. And as to such count, your foreperson would place a mark in the box that says not guilty. So, we have prepared those choices under each count of the indictment. Ladies and gentlemen, I charge you that the law does not permit jurors in arriving at your verdicts to be governed by sympathy or by prejudice. You may not therefore render a verdict in this case based solely upon or based upon your sympathy for any party or your prejudice against any party. Any verdict that you return must be supported by the evidence produced at trial without in any way being affected by either sympathy or by prejudice. Ladies and gentlemen, by no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or the innocence of the accused. Now, ladies and gentlemen, as to sentencing, you are to concern yourselves only with the guilt or innocence of the defendant, and you are not to concern yourselves with punishment. Now, one of your first duties in the jury room will be to select one of your number to act as foreperson. And that foreperson will preside over your deliberations and will sign the verdict form as to which all 12 of you on the jury must freely and voluntarily agree. Now, you should start your deliberations with an open mind. You should consult with one another, and you should consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion merely in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, it must be unanimous. That is, it must be agreed upon by all of you. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. Ladies and gentlemen, I'm now going to send you back to the jury room, but I ask you not to begin your deliberations until you shall have received the verdict form, the indictment, the charge of this court, and all of the evidence, that's been admitted in this case. Now, we do have 3 of you in this case. Usually we just have 2 alternates. This week we had 3. And I would ask Ms. Tristan if she would tell us who the alternates are. All righty. Can y'all raise your hands? Thank you. Now, if each of you would, you can remain for just a moment because y'all will be taken to the jury assembly room.
Yes, sir.
And y'all will wait in the jury assembly room. It's important that you still remain. It's very important as the trial goes on for several days. And I don't know if you noticed, but your court has been trying to get over a head cold. And it's been plaguing me for like the entire month of January. I don't think I've ever had a cold that's persisted quite this long. But but I know that we all know that anybody could get sick at any time, and so it would be. And if we lost our jurors, we would have to start trial all over again. So what I would ask that y'all do is, I appreciate the service that the alternates have provided. We'll talk more about that in a few minutes. But the rest of you, I'll ask to step back into the jury room and to set about the job of selecting your foreperson. Y'all go ahead and do that immediately, and then don't begin your deliberations until you have all the other materials, which will be there in just a minute.
All right, for the jury.
Do we have a stapler? Can you put a stapler on this for me, please, ma'am? Thank you. All right, well, y'all can be seated. Y'all are the alternates, and so in Richmond County, you would go into a closet, and where they would keep you. It's not much bigger than the closet, unless we just happen to have an extra jury room available. So we don't have very good digs for our alternates. But in this case, we're still going to keep you until the jury reaches a verdict. Should somebody take ill or have problems or some other issue arise, you might be called upon to replace a juror that's now deliberating. I'll just tell you, just because I know that y'all wonder about these kinds of things, if that were to happen, the jury starts its deliberations afresh. When the new juror goes in, if that were to happen, and this happened several times in my experience, but the jury would be instructed to begin its deliberations from the beginning, start over, and then but with the new juror in the mix. Y'all will be waiting in the jury assembly room, which is a very pleasant place. Y'all have looks like a little coffee shop in there, isn't it? And so I'm going to ask y'all to go with the bailiff and to the jury assembly room, and where you will be brought out. Every time the jury comes out, if they have questions or any issues, y'all will also join us, okay? Thank you.
All right.
And John, who's got the jury? Nathan, who's got the alternates for the jury? All right, let the record reflect, everybody can be seated. Let the record reflect that the alternates are now out of the courtroom. The jury is also out of the courtroom. Counsel, I know that each of you have a number of objections to place on the record to the charge. Anything that other than what we had discussed yesterday, any corrections or that we need to make with regard to the charge that the court just gave?
No corrections, Your Honor.
All righty.
Stay.
Thank you. So I would like to hear your arguments placed on the record.
Thank you, Your Honor.
Judge, before we do that, can we send the evidence back?
If you would y'all proud to do that?
I would rather get the objections out and that be done.
All right, why don't you go ahead, Miss? We'll let the Miss Payne. Can you double multitask? All right, Ms. Tonker, you might state your objections.
Thank you, Your Honor. The defense would object to the failure to give defense request to charge 15 and 16, just stating that it is never error to charge voluntary manslaughter, and further, because I don't think it was taken down yesterday during the charge conference, I just want to make sure it's on the record that it is your ruling that there was no slight evidence and that you are choosing to not charge based on the defendant's sole defense. Further, the failure to, after that charge conference, the failure to give defendant's amended request to charge number 17 and 18 further constricts the defendant's ability to have any defense and essentially chooses the defendant's defense for him by determining that accident was the charge that would be given. Further, by refusing to give those lesser charges, I would renew my objection to State's charge 16 of juror sympathy and prejudice without the option of a lesser included offense. It certainly is not an issue to worry about the jury nullification, which was the issue that was brought up for that charge.
Thank you, ma'am. Those charges are noted and overruled, or those objections, I should say. All right, Ms. Payne, you had an objection as well,
I did.
which you've now abandoned,
I think.
apparently.
Yeah.
All right, that's fine. Thank you. I think the charge that you objected to was yesterday was bare suspicion.
Yeah.
Pardon?
I mean, I objected to bare suspicion yesterday, but I mean.
Okay, that's fine. All right, anything further? Thank you. Ms. Dunbar, you might assist in the scoping out the evidence. Andrew. All right, can we make sure one thing is the gun secure so that such that, okay, thank you. All right, thank you. Any other issues we take up before we recess while the jury deliberates? And of course, the court will not actually take a recess because we're going to move directly into any other matters we might be able to handle. Anything further? Madam DA, anything?
I don't have anything with me.
Ms. Dunbar, anything? I'm talking about this case.
Oh, no, Your Honor.
All right, thank you. We're in recess as to the Schmidt case. And Ms. Schmidt, you might return to your digs. All right. Ladies and gentlemen, anybody else having other business before the court? We actually have a very full calendar for today. And but it's not scheduled to begin until a little bit later. But if you're here and your counsel's here and we can put everybody together, we'll go ahead and move those cases.